One of my favorite parts about the opinion in this case is not the opinion, but the concurrence, talking about generic boilerplate motions in limine. I can't tell you how many cases I've been involved in where a defense firm moves to exclude evidence of any and all settlement communications, insurance, etc., without identifying specific evidence and without any particular analysis. It's a cut and paste from some forms file from some senior partner. It drives me crazy. I would hope that the caution in this concurrence would help with this problem in Georgia, but I've seen similar concurrences in California, and it hasn't helped here.
Well, Jeff, I'm glad you brought that up because one of the questions I was going to ask you guys is whether the practice in California is as prevalent in Georgia. The motion in limine that gave rise to the controversy in our case was the 33rd motion in limine. And it was not the last. There were 40-something motions in limine, ranging from, exclude any evidence of this prior settlement, proper, to the ones we've just been talking about. Don't let the plaintiff do anything prejudicial.
Right.
And I do know that has been a source of real frustration for Georgia trial judges. I've heard some of them speak on it publicly. Essentially under the heading of stupid motions in limine that have been filed in front of me. And I do hope that practitioners will take Justice Bethel's special concurrence to heart, although I hope that they don't, I hope that the trial judges don't read his concurrence as saying they should deny all these motions, because they may create a preservation that they don't mean to. They need to be clear in using the language that Tim suggested earlier, that I'm deferring ruling or I'm denying this as too vague. You're going to have to renew this at trial.
Yeah, that's a very important distinction. And just to clarify for our listeners, the contemporaneous objection requirement is the rule in California. The California Supreme Court case is Warner Construction Corporation versus City of Los Angeles, where it says that in the absence of a timely objection, the offended party is deemed to have waived the claim of error through his participation in the atmosphere which produced the claim of prejudice.